Number 1881 CB 2385, City of Waltham versus the Trustees of the Stigmatines Fathers. Would parties please identify themselves for the record?
Attorney Michelle Learned for the City of Waltham.
Attorney John Cerrone, City Solicitor for the City of Waltham.
Good afternoon, Your Honor. Jason Scola for the Stigmatines Fathers.
Good afternoon to the council. We're here on the motion for summary judgment. I guess it's a continuation of the motion for summary judgment hearing that we had maybe a month ago. I'll hear from the moving party.
Yes, Your Honor. On a preliminary matter, I just wanted to address some of the matters that the court had advised or admonished us to address. And one of them relates to several suggestions about proceeding with.
Is this attached to your pleading or is this something new?
This is something new, Your Honor. It's just a sort of a follow-up or response to other admonitions we had received from the court the day we were here.
All right, I would like to hear from you on your motion for summary judgment.
Yes, Your Honor. At the outset, I think it's key, and I apologize that we didn't raise this the other day, but on a basic level, there is a problem with the opposition in terms of how it talks about the statute. Because all of the statutes that it describes in terms of its interpretations, the defendant either adds words that are not there or ignores words that are. So, for example, its key argument is that somehow, even though there are no cases that support this position, something in Chapter 79, and he suggests that it's somewhere in Chapter 8, Section 18, gives the landowner a unilateral right to prevent any action from being conducted to clear title or address title issues until after 3 years. The one simple way that refutes that is within the same statute that he addresses. Section 22 says that after a petition is brought under Section 14.
Section 14, what does that relate to? Doesn't Section 14 relate exclusively to an assessment of damages challenge? And since
Yes.
Section 22 in turn refers to, directly to 14, both Section 14 and Section 22 relate to challenges to the amount of money being paid, not challenges to whether or not the taking is violent.
I'm not disagreeing with what Your Honor just said, but I guess my point is his argument that you have to look at all the sections of Chapter 79 together by its own terms under Section 22, which interplays with Section 14, because it says a complaint brought under Section 14 requires any defense. I have a copy if Your Honor.
No, I'm just looking, I think I brought the statute. Now, could you do me a favor, and I think I brought Chapter 79 back into my chambers. I spent quite a bit of time with the statute this week, so
Yes.
let me just grab it off my desk. Yeah. Do you still want me to go to Section 22?
Yes, Your Honor.
Right there.
Any defense to the petition not relating to the amount of damages shall be pleaded within 30 days after service of process. That clearly undercuts their interpretation that somehow something in Chapter 79 says they can unilaterally delay any kind of lawsuit.
I'm not following you. So by its terms, by the first section,
Yes.
sentence of chapter 22, it
Yes.
says, a complaint brought under section 14
Yes.
shall name all parties adversely. So this whole section 22, as I read it, relates to complaints that are brought under section 14, does it not?
That's correct, Your Honor, which we have.
And section 14 relates to the award of damages.
Absolutely, Your
Or
Honor.
in as the courts have interpreted it, it's the sort of the assessment of damages portion of chapter 70.
Yes,
Complaints relating to the amount of money that was paid,
that's correct, Your Honor, and we have filed one.
right?
We have filed such a petition.
So, but that's separate and distinct from what is embodied in section 16 and section 18, which are challenges relating to the validity of the taking by eminent domain. So the law has developed such that the courts now recognize that both types of challenges, challenges to the amount of money being paid and challenges to the validity of the taking, are two separate types of challenges that the parties may bring.
Correct.
Some parties may bring, depending on how you interpret the statute. And the law recognizes that when possible, those two things can be properly brought together. The
Agreed.
predicament here, it seems, is, to me, that if I read section 16 and section 18 to be that the defendants in this case have the exclusive right to challenge the validity or have a statutorily, it doesn't have to be exclusive, they have a statutorily protected right under chapter 79, section 18, to challenge validity for a period of 3 years. So says the legislature. And it seems to me that that period, which was initially as the statute was drafted, was 1 year. In 1962, the legislature decided that they wanted to up that to 2 years. And in 1982, the legislature decided that they wanted to up that to the present day 3 years, where it stood since 1982. The legislature has, in doing so, one interpretation of that is that they believe that that's a reasonable period of time that balances the interests of the parties, the competing interests. On the one hand, the power of the entity, your client, to take by eminent domain personal property owned by a third party, with the rights of the taker to have some certainty in what they have acquired by eminent domain. And the legislature seems to be telling me that the defendant gets 3 years to challenge the validity of that taking. And so what I come back to, if that is my interpretation of what the statutorily protected right that the legislature gave to defendants that are similarly situated to the defendant in this case, who am I to say that they got it wrong? Who am I to balance it differently? I'm here to interpret and follow the law, not make law. And so, what I said previously is, are you inviting me by virtue of this summary judgment motion to disregard section 16 and section 18 and say that statutorily protected 3-year period that the legislature has built into the eminent domain statute should be extinguished in this case?
No, I'm not, Your Honor, it's actually the opposite. There's no case anywhere that actually interprets, that's why they've not cited one. There's no case, and they implicitly admit that in their opposition.
There's
It says
no
that.
case, I've looked for them.
Yes,
There
yes.
is no case in which the plaintiff, taker, has affirmatively used declaratory judgment to extinguish this right. It doesn't exist. The cases that you cited to do not stand for that proposition. I've read them over and over and over again, and they do not cite the proposition for which. So to say that there's no case law on his side, there's no case law on either side of this, because the way the law has sprung up is come up with a number of times where defendants or people in the shoes of the defendant have failed to timely raise their rights. So it's gone beyond the 3 years. Sometimes a lot of the cases actually were in the 1 or 2 year periods that I spoke about before. And the court said, it's an absolute dead end. It's a stop. It's 3 years, it's 2 years, it's 1 year, whatever it was at the relevant time period. And if you didn't preserve your right within that time period, you're done. It means something. But embedded in those cases is quite a bit of dicta from higher courts, the appeals courts, telling me what that statute means, what section 18 means, and how they're interpreting it. And that's why I turn to those cases for guidance. Not because there's any holdings out there, because to the best of my knowledge, neither of you have cited me to cases. And I'm not saying that there's any fault in this. I don't think that there are any cases that are directly on point. I have been unable to find any cases in which the taker has affirmatively used the declaratory judgment statute or any other statute to, my words, truncate this 3 year period that's provided for, it seems to me, in section 18.
Can I address on the statutory, I'm not, I'll give it to the cases after, but on a statutory level, just textual, there's two things that are fatal to that argument by the defendant. One, they claim that section 45 makes chapter 79 the exclusive proceeding and law on which to address and look at any aspect of a chapter 79 action. But in fact, section 45 only talks about no damages shall be assessed except under chapter 79. And then when you look at that limitation, because throughout chapter 79, there's a reason the terminology is called, they talk about petitions for the assessment of damages. And they refer to a petition and assessment of damages together throughout the sections of chapter 79. However, looking, and I missed it the first time, Your Honor, when I looked closely at section 18, section 16 is just a general statute of limitations. Section 18, all it does, and it uses the words very, very differently. It dichotomizes the word suit from the word petition for the assessment of damages, and it does it twice. And all section 18 says, the fairness of it makes sense on this level. All it says is if a suit differentiated from a petition for the assessment of damages involves the question of the taking, and it is resolved against the landowner, then as long as the first suit was brought within the section 16 time for filing, then a petition for the assessment of damages can be brought within 6 months of the unsuccessful petition of the landowner. Now, that's all section 18 does. It creates no substantive rights. It creates a procedure to allow a landowner who perhaps put all his eggs in the basket of challenging the taking not to lose his chapter 79 right to assess damages. And it does it twice. It differentiates assiduously the use of the word suit, differentiated and dichotomized between the word petition for assessment of damages. And it's only talking about extending time or giving a specific period of time for the petition for the assessment of damages, not anything else. I have a copy of section 18.
I have the statute. I've read it, and I've read every case that I could find reported with regard to its interpretation. And what you're suggesting is not consistent with the dicta in many of the cases that are read.
Well, the only cases, with all due respect, I know you talked about the White House case. Again, all these cases talk about the statute of limitations in
There's
section
one
16
case-
being missed.
One case you want me to look at that supports your interpretation of section 18. What's that case?
All of the White House case specifically says, they specifically ordered the court to issue its judgment in the form of a declaratory judgment. And all it said was, even though there were major violations by the town of the sections of chapter 79, because the landowner failed to bring the action within 3 years, he was out. It doesn't say no declaratory judgment action could have been brought within preceding 3 years anytime by the individual town.
It wouldn't have addressed that. There was nobody seeking declaratory judgment in the case. Why would the court have said no declaratory? Why would they have addressed it at all?
It explicitly directed, because the lower court had done it as a motion to dismiss based on statute of limitations, and the appellate court specifically admonished that it should be done as a declaration of rights between the parties.
What is different in each of the cases that you cited from the situation here, and in particular, the two cases that you rely on for the thrust of your argument, the Stockbridge case involves a situation, called the traditional situation, where the plaintiff was seeking a declaratory judgment. It was not an offensive act by the taking authority. It was raised by the aggrieved private landowner. So too, in DiBiase,
Yes, Chelmsford, yes.
DiBiase. So too, in that case, both parties were actually raising the propriety,
Exactly.
but importantly, the defendant was on board. The person that's in the situation of the defendant in this case was on board with bringing the challenge to the validity and had raised the challenge to the validity. The predicament that the town finds itself in right now is that perhaps for strategic reasons, perhaps not, but at least you raise it in your pleadings that it is for strategic reasons. The defendant, aggrieved party, has decided not to seek a declaration of its rights with regard to validity, and is resting back saying, I get 3 years to make that decision. I get 3 years to, under the statute, to do whatever discovery I need, to put myself in the strongest posture to bring that challenge, or even decide whether I want to bring that challenge. And for those 3 years that the statute says I have to raise that, you can't, other than by some outside agreement that would asphyxiate its rights under Chapter 18 by agreement, by the defendant's own agreement. You can't make me do it, so to speak.
Again, with all due respect, we've already done that. We filed in Chapter 79, Section
He's
14
asking
action.
for it to be thrown out because he's saying that you can't do it because he gets 3 years under the statute, under the eminent domain legislation, as the legislature has passed it. They've given me 3 years to make this decision.
Again, all I can say is that's directly contradicted by Section 22. It's directly, they have 30 days to raise it. And
Section
again,
22 has to do with assessment of damages.
yes, that's what I'm talking about.
It is not a challenge to the validity. So while you're right, perhaps their time to challenge the assessment of damages may be shorter. Perhaps. Section 14 and Section 22 22 both relate to assessment of damages challenges, not validity.
With all due respect, it deals with both. It says anything other than the assessment of
I asked you that
damages.
earlier in the hearing, and I actually thought that you answered my question. I'll go back and listen to the tape. I thought you answered my question that you agreed that section 22 has to do with the assessment of damages.
No, Your Honor, it specifically states that any issue other than the assessment of damages must be pled and raised as a defense within 30 days after service of process. Second sentence, Your Honor. It does talk about, and it says, if they don't do that, basically, the assessment of damage issue is always open. It's similar to what Section 18 talks about, that the assessment of damages issue is always open. But Section 22 explicitly states they have 30 days to raise any non-damages issues, otherwise they're lost. It does say their assessment of damages issues may not be lost, but any other defense, claim, or action has to be pled within 30 days after service of the
So
complaint.
your argument is that section 22, even though it refers directly back to section 14, and that says a complaint brought under section 14, your argument is that section 22 is not limited to assessment of damages, and that therein, in that second sentence that starts with any defense,
Yes.
requires or allows you to raise the petition that you're raising now, and that they have to respond in 30 days.
That's
Is that
the
your argument?
text. Yes, Your Honor. And in itself, that is totally inconsistent with their argued interpretation of Section 18. The two, Section 22 and Section 18, in terms of how they interpret it, can't coexist. They're mutually exclusive. If we're just looking at a textual,
Well, they can coexist if section 22 relates to assessment of damages only.
no, okay.
The only reason that section 22 and section 18 can't coexist is if you're right, that second sentence of section 22 broadens the application of section 22 to a validity challenge.
Yes.
Then it seems by its terms under your argument of the statutory reading that section 22 would truncate section 16 and 18's 3-year period.
Yes, Your Honor, but again, also what I'm saying.
So how am I going to interpret a statute to be under basic tenets of statutory construction? You're asking me to adopt an interpretation where to broaden section 22's application to challenges to validity in addition to assessment of damages, knowing that in doing so, I create a disconnect then between the meaning of section 18, which is that he has 3 years on a validity challenge.
Can I respond? Just briefly, Your Honor. Again, when I look at their section 18's very, very specific dichotomization of those two words, petition versus suit.
And is this something that was in your brief? I don't remember reading it. This argument that you're making, this dichotomy of language is in your brief?
Yes, not to the extent that we're doing now, but yes, it was.
So where is that so I can read that carefully?
And it's in the reply also.
I'll get the brief out and then you can point me to the page so I make sure I read that carefully.
It's two places in the reply. On page 1.
Let's talk about the first brief.
Okay, sorry, Ron. And if I,
So in it's docket 23.1. And this is the argument on the dichotomy of the language in section 18. So you're pointing me to, is that right?
I'll be candid, Your Honor. We only touched upon it in the reply, but again, when I went back and reread
All
it,
right, is it in the brief, the opening brief at all? Just yes or no?
I'm not, I have to defer to Attorney Lerner on that.
Your Honor, if I could, there is there's probably a page about section 22 language triggering the responsibility for the pleading once the assessment of damages action is filed. And I'm not sure if we were clear enough, but the city has also filed now that assessment of damages petition.
Well, we're gonna get to that in a moment. I haven't raised it, but I'm gonna ask you about that in a second.
So
Because that's not the motion that I'm hearing argument right now, but it's on my radar. It's
Correct.
something that I need you to explain
Oh.
today before we leave. But
and then
what I want to just stick with my question, where in the opening brief, and if it's not there, just say it, it's not there. If it's there, point me to it so I can read it carefully.
Okay, I saw your question as a two-part question. The second part of the question, which is how my pointing out the dichotomy in section 18, and it only relates when you read section 18 and the dichotomy between the word petition for assessment of damages. Section 18 only relates to the assessment of damages. To be candid,
You don't mean section 18. Section 18 does not only relate to assessment of damages. You're talking about
Yeah.
section.
well, I'm saying the application of it, I'm sorry, Ron. The application, by dichotomizing those two words twice within section 18, suit differentiating from petition for assessment of damages, all section 18 does is say there can be an extension of time on the issue of petition for assessment of damages after a landowner has lost on the issue of any challenges, any other challenges, but it specifically relates to the timing and extension of time, and basically saying they don't lose their petition for assessment of damages if there was another action that didn't raise that and they didn't raise it. But it only says what's preserved is the petition for assessment of damages. It doesn't say other things are preserved.
I'm not sure, I still am not sure I understand your argument, which is why I'm going to ask you now for the third time.
Yes.
Where in the brief do I find this argument?
It's not in the main brief that I know
It's a
of.
statutory interpretation argument, it clearly is.
Yes.
So where is it in your brief?
Your Honor, I believe it's at pages 8 through 9
Of the opening brief?
of the opening brief with respect to the analysis of those two sections. I do think that the city solicitor has augmented that argument today in court by discussing the dichotomy of the words petition for assessment of damages and the word a suit. That is an additional argument for you that I believe he has expressed here today that goes
No,
beyond.
they're not expressed in the third page of the brief. That's just,
Correct, Your Honor.
and so it's not in the reply brief either.
It's at page 1 and 3.
Of the reply
Of
brief.
the reply brief, Ron, sorry, Ron. And I'm looking, I'm up in the footnotes. In all candor, Your Honor, it is not made as clearly as I have articulated in response to your
I'm struggling
questions.
with the argument here, understanding it, which is why I'm looking for your briefing to illuminate that to me. I'm not following the argument that you're making in court with regard to the statutory interpretation, and I'm looking for you to tell me where in the brief I can look to study that and better understand it. That's simply my question.
No, I understand, Your Honor. And I guess in terms of the section 22 refutation of section 18, it's on page 1 and 3 of the reply brief. But if you're also asking my textual argument that I just presented about the dichotomy that section 18 uses with the words petition for assessment of damages being the only thing that extends the time, it is not clearly raised.
Anywhere.
Yes, Your Honor.
All right? anything else you'd like to say? With
Um,
regard to the motion for summary judgment?
The only other thing, again, it relates to, similar to the text, the statute's contextual argument, the defendant's opposition really does the same thing. It omits portions of a case or misstates portions of a case or adds things that aren't there. For example, it says that the certain cases prove its point that procedural errors in the taking under Chapter 79 can still be a matter that prevents and is proof of bad faith that can void a taking, despite what Section 10A of Chapter 79 says. And that's
I
not,
have to say that both of you in your brief spent a lot of time talking about whether or not there was bad faith. And although I think that that is something that needs to be decided at some point, it falls entirely to this issue that we've been discussing. Because if Section 18 is a 3-year period for the defense to raise the challenge to validity, the case is gone. And then there is no discussion about whether there was good faith or bad faith or any faith at all. It is just prematurely brought. So I know that that was something that you spent a lot of time discussing before Judge Horatius. I know that there was this 2-day hearing in which that was front and center. But I was a little mystified when I was reading the briefs as to why both of you spent so much time discussing that issue. And I think it was sort of left over from this is my read as the judge, it was sort of left over from the last briefing when the first summary judgment papers came in and were very much focused on them. It seems that this issue that we've been discussing so far subsumes that entirely. And is, I think I'll say, if the case were just here on the merits of whether there was good or bad faith, it would seem to me that that's a case that's going to the jury. This is a procedural challenge, really. That is being raised by the defendant as to whether or not you can raise this in this fashion in light of the eminent domain statutes as the legislature has drafted Chapter 79.
hearing what you're saying, Your Honor, I have an idea or suggestion, however you want to turn it. Understanding what you're saying about this seeming like there's no cases on either side, it's a matter of basically first impression. Perhaps this might be something that the court should report on.
I don't think it's that kind of a quality of a nature. It will get reported up because one side is going to win and one side is going to lose. And it's going to either result in the case going forward because I decide that Section 18, there is no 3-year period. These are my sort of 3-year period that the defendant has to raise this, and the case can go forward on the declaratory judgment and the case moves forward. Or I decide that it would be violative of Chapter 79, Section 18 to force the defendant to engage in a challenge on the validity before the 3-year, he's got 3 years to raise it, and then the case goes away, and then you'll appeal me up to the higher authorities, and they'll figure out what the statute really means if you disagree with my interpretation of the statute.
And just to address respectfully your, I'm trying to follow some of what you were saying. You asked for any other cases that would compel or be consistent with what we've been
They're
arguing.
consistent with your statutory interpretation
And
of Section 14, of Section 22, and whether or not that's limited to assessment of damages. My reading of the cases that were under Section 14 and under Section 22, all related and exclusively related to challenges on the assessment of damages, although those cases may have simultaneously brought validity challenges. And that went back to what I said to you early on, which is the case law has embraced this idea that both validity and assessment of damages challenges should be brought together. So in many of the cases in which these statutes are discussed, 14, 16, 18, 22, They're discussed in the breadth of the same opinion because challenges to both the amount of money being paid and the validity are being raised together. So
I understand.
that doesn't necessarily make the interpretation of section 22 broader than what it appears to be on its face and what it's been dealt with in the cases that I've looked at so far. They do talk about section 22 as being an assessment, the assessment of damages, tool and prong of chapter 79. So
And again, Ron, I know what you were saying about, you were looking for something to sort of help in the balancing, and you said you read some dicta. And so in response to that, I had, it seems to me, and this is just a basic argument that relates to cases that are legion. Leclerc and other cases expressly state that the court should look, when it's a matter of significant public interest, should look to advancing such interests, which is why in Leclerc they ignored a potential, an actual technical violation of the conflict of interest and said, because of all these reasons, and public schools are absolutely matters of public interest, we're going to side on the matters that push these forward at a quick pace so as not to cause problems with delaying or costing the taxpayers more money. And the cases are legion that say if the courts need to pay attention to how a matter of public interest, if it's going to affect and cost the taxpayers more money, that is a matter of public policy that should be followed, not one to be ignored. And the upshot of what they're saying in their interpretation is, you give them an extortion gun because they have the right. Say there's an emergency. Let's say there's a giant barge that nails the bridge coming across from Route 1 to Boston or anything like that. And there needs to be an immediate emergency taking and construction. What they are saying would mean all it takes is one person along that route to say, I may do something in 3 years, so you can't proceed. That is absolutely contrary to every public policy case that is out there relating to.
Leclerc is a very different situation than what is presented here for the plain reason that the legislature decided that eminent domain was so important that they were going to develop the rules and regulations in Chapter 79 to how that was going to be orchestrated. This very difficult challenge between balancing the rights of an individual landholder to have a public entity take its land away from it. The legislature has spoken in Chapter 79 to how that is going to be handled. That was not at all at play in Leclerc. At the end of the day, the town, I am not insensitive to the fact that this town needs a new high school. I'm not insensitive to the fact that this litigation may in some way be delaying. But the town chose that where they were going to build a high school was on land that they chose to take by eminent domain. And one of the, in doing so, one of the things they ought to have been looking at was the rights of an individual, of the defendant, when you take land by eminent domain. Among them are whatever protections Section 18 and Section 16 give. Is that costing the town money? Perhaps delaying the project? It may, but it does not, that delay and the interests that are mentioned in Leclerc and as being important to the court, it's a different dynamic in that case than what presents here, given the breadth in the work the legislature put in place that is memorialized now by Chapter 79. It's different.
I hear what you're saying. I hear and understand what you're saying about the distinction with Leclerc, but again, one of the reasons there's probably never been a case that supports their position is because in situations like this, whether it's an emergency taking or otherwise, there would never, what you're talking about, and I understand there are rights of individuals, but the rights of the Commonwealth and its citizens are discussed in every eminent domain case. And all the cases that talk about that, including some of the defendant citations, when you look at the footnotes, they talk about, one of them was Justice Holmes. He said, yes, there's a balancing, but one of the considerations is the need to take care of public good and public safety and proceed quickly and have a determined and definite resolution. That's part of the reason.
But the legislature has done the work for me in that regard. They did the tough thinking and said, what's the proper balance of time that gives the landowner the proper amount of time and gives the taker the proper amount of time? That there is and if anything, the legislature has decided over the years between 62 and 82. 62 they upped it from 1 to 2, and 82 they upped it from 2 to 3, indicating some, they've done the balancing act for me.
Yes, Your Honor, and I think Section 22 is basically said they've got 30 days once the actions.
I understand that's your interpretation of the statute.
If I could briefly, Your Honor, I think there's a critical distinction, and I hope this helps when you're looking at the cases. The whole statutory scheme is set up to challenge the damages. So when you mention, Your Honor, that the legislature has set this up, they did indeed set up this statutory scheme that would permit a landowner to challenge within the 3 years. Section 22 is the language that says, and it's very clear, any defense to the petition not relating to the amount of damages shall be pleaded within 30 days after the service of process. I think the legislature there, Your Honor, is specifically discussing exactly what you're concerned about with respect to what do you do when there are these emergency situations and how to effectuate that needed balance. I mentioned, I hear that the court, and I know that my opposing counsel has mentioned this, that there's a statutory right to the validity challenge. I just would like to urge this court to look at those cases. Section 18 does not provide a statutory right. Again, it's part of the legislative scheme about damage petitions. It's the heading is not considered under the rules of statutory construction. What that section does is permit more time if the if a suit is ruled against them. Section 18 itself still remains a section about assessment of damages. So when the courts in the cases that you've looked at have analyzed this, they're looking to adopt the 3-year time frame. All of the cases that the landowner has cited are all equity petitions when they are challenging the validity of a taking. And I think that's a critical distinction, that there's equity petitions that is the law that permits validity challenges. And so the language of 231A, which expressly gives landowners the right to have their title cleared, is the same body of law which the entire validity challenge law comes from. So I just urge the court to look again at at both section 22 of chapter 79 and chapter 79 section 18, because section 18 still remains applicable to the assessment of damages. The entire scheme is set up for the assessment of damages. The Constitution doesn't bar takings. it bars takings without just compensation. So this legislative scheme is designed to make sure that they receive just compensation. By letting that 3-year statutory statute of limitations period be used this way, they are in a position to gain more than just compensation, because it forces a city who has these emergency situations to, in order to have the construction built, it forces a city to pay more than the fair market value of the property. And so the entire legislative scheme,
Or not, and be prepared to wait for 3 years.
which increases the
Overall cost of the project.
overall cost of the project and puts the city in a position that it could lose a large amount of funding from the state. I hear your, obviously, it's a very important
First of all, with
issue.
regard to section 18, the title of section 18,
It is true, I
the
see
title says time for filing a petition when validity of the taking is contested.
the rules
It
of,
specifically says, this is the section that you look to, Judge, when you're looking at timing for validity challenges.
I do see that, Your
That's the
Honor.
title.
But under the rules of statutory construction, the titles are not considered law. And it's what West attaches to them. There's numerous cases that do say that. And again, I urge
Well,
you,
and apparently the appeals courts has fallen into that misunderstanding as well by virtue of the cases that I'm reading in which they interpret.
and
So the appeals court, perhaps the SJC, I'm not sure, I haven't studied these opinions to know whether they're just the Mass Appeals Court. Some of them are Mass Appeals Court, some of them are the SJC. But they uniformly refer to Section 18 by what the title says, which is, this is the time limits for challenges to validity.
I understand, and I see that predicament. I do think it was that case that did an analysis that mentions the borrowing of the statutory scheme, so that it outright comes forward and says it's not a statutory right, it's a remedy, a 231A, a equity remedy, where they're just borrowing that statutory time frame. We understand, Your Honor, that this is arguably a case of first impression. We urge the court to be focused on Section 22, how you harmonize these particular statutory sections and not negate out the language, any defense to the petition not relating to the amount of damages. If we accept the landowner's interpretation of this statutory scheme, it renders that language superfluous, and it negates it, and that's definitely not something the rules of statutory construction permits.
All right,
And
I'm
then,
going to ask you to wrap up. You've been arguing for an hour already on this. I can hear from the defending party on the motion for summary judgment. I'll hear from the defending party. I'll give you a bite back at the apple after you've heard.
sure,
But it's going to be a 5-minute rebuttal. Go right ahead.
Thank you, Your Honor, and I'm actually going to be extremely brief. I would like to just comment on Section 22. As Your Honor has pointed out, the first sentence is a complaint brought under Section 14. This is not a complaint under Section 14, so the rest of Section 22 is meaningless for the purposes of this case. But if we were to play the game and look at the second sentence, which says, if it was a Section 14 case, all defenses would need to be raised. All defenses that don't relate to damage.
It seems to me that when I read this before, and I'm going to go back and look at the statutory interpretation, what I believe this means is this section does deal with assessment of damages. When you get an assessment of damages petition, if you have a defense that relates to something other than assessment of damages, you need to raise it now.
That may be, Your Honor, but again, this isn't that case. And think
I know it
is.
isn't. That's the other case that they filed back on September 9th, which we're gonna get to later in a moment. But it's not the case that's before me.
That's my only
It's the
point.
case that's now in a different session.
That's my only point. It is not the case before you. And if I were to go through the rest of my argument, Your Honor, I think I'd just be hitting on the points you already made. I think where the town cannot show you that 231 can be used in this way, respectfully, I think the court is compelled to dismiss count 1 and enter summary judgment in favor of the Stigmatines Fathers on that count.
Alright. So, I'll have you back.
And I'm
And
sorry.
I'm gonna give you less than 5 minutes because his whole argument, which was less than that. And the imbalance, by the way, is not necessarily, it's provoked by sort of my questions. And so, I've spent a lot of time before this hearing reading the cases, reading the statute, thinking about what this is supposed to mean. And so you got the brunt of my fire since you were the arguing party. But I do want to give you a few minutes to wrap up, and then I want to talk about the other, 2 other things. I want to talk about plaintiff's emergency motion, and then I also want to talk about what's raised in the opposition, which is this September 9th filing. So first, wrap up your argument.
Sure, I just wanted to, like when we here last time, you asked to give you whatever cases or whatever authority we could find to support our position. I also wanted to alert the court to the existence of counterclaim law also supports the cutting off of the 3-year statutory period. There is nothing in Chapter 79 that says it's somehow elevated, that this statute of limitations period is elevated above any other statute of limitations period. So an example for the court would be just the existence of counterclaim law. And so when this action was filed, certainly the defendant had the ability to.
But they didn't. They didn't take the bait.
Correct.
And that is how a couple of other cases have presented. That is, it seems that one party raised the issue of validity and then the other party counterclaimed and said it's not valid. I think it was almost always the other way around because otherwise we'd have this situation. So that side of the party in other cases have raised it wasn't valid, and then the counterclaim came in and said, yes, it was, and we have claims as a result of the validity. They didn't take the bait. Had they done that, I think that then we wouldn't be here. All right.
And then the only other thing is when we were here last, you had requested if there was a way that we could separate the relief that we were requesting. So all of the concern with respect to whether or not standing exists is connected to the bad faith allegations. We do present in our motion prayers for relief at the bottom of page 5 and 6 with how we think that issues related to the vesting of the title could be resolved without having to resolve the standing issue. And perhaps the standing issue that is involving bad faith allegations could be deferred until such time as the newly filed complaint could be consolidated with this complaint.
Well, honestly, I don't think that, I think the answer to this question results in either the case going forward on its merits or the case entirely being dismissed. Because if I find that Section 18 permits the Stigmatines Fathers to have 3 years to raise their challenge to the validity, the case is going to be dismissed. The case that you brought. Whether or not the case that you then filed on September 9th following. So as I understand, and let's move to that, as I understand it, we have a hearing here on August 28th or 29th in which these issues were made known to, the issues that we've discussed today. I requested, because of the non-compliant briefing, that the issues be rebriefed, and by that point had a focus in my mind as much of what we've discussed today. And we set up this date. Following that, on September 9th. Yes, it is September 9th. I just want to get it on me. Following that, on September 9th, the city filed a new complaint. And in that new complaint, makes much of the same arguments as you made in your first complaint, except you rectified some of the issues that are uncovered by this present summary judgment motion. And you filed that as a new case. You did note on the cover sheet that there was a related case. My question to you simply is, why did you do that? And why didn't you just file a motion to amend the complaint?
Two reasons, Your Honor. One, their original opposition raised, and it basically admitted that since they haven't brought a Chapter 79, Section 14 case, which they could, as the statute says, because it says porta potty politic, that is the reason why there was a standing problem, and what they're raising is premature. They were the ones, in a sense, who raised it. The other problem is timing. We are under problems with the MSBA's $120 million funding is such that if this money is not spent within this cycle, and I have a copy of a letter from the MSBA confirming this, within the current budget cycle, it gets lost. We don't get to keep asking for them to hold it because they have to spend it within their current budget cycle. And as they've noted, and I have a copy of the letter if you want to like,
I don't need one.
then since it's a competitive process, we're not guaranteed to even be among those who have been considered to receive an award in this next budget cycle. So truly, $120 million is at risk if we don't move
So
quickly.
answer my question, why didn't you move to amend the complaint?
It would-
It is substantially the same complaint, except it is, well, first of all, let me ask you another question. It seems to me that there is no reason that these cases shouldn't be decided by the same judge. As a matter of efficiency, it has been, I don't know how it went to the J session, but it seems to me that if these cases are going to be, if the case that we're now here on survives this summary judgment motion, it's inevitable that these cases are going to be consolidated. Does anybody disagree with that?
I'm not disagreeing that it should be. I can guarantee you that if I brought a motion to amend, not only would it have added a month to things, I would guarantee that they would be opposing.
But where are you going to, you filed a brand new case, where are you going to be in a month on that case? If it's about speed, that wasn't going to achieve your goal any faster. This is a brand new case. It's not even going to, depending on what the posture of the case is, it's going to get a discovery schedule, it's going to get a whole other schedule that's going to be well behind the 2018 case.
But then, under Section 34, as the defendant concedes, we can move for a very quick timeline
On the assessment of damages.
on the whole case.
All roads lead back to the same decision.
I'm not,
You you may very well be able to proceed on the assessment of damages case, but even if he has to respond under section 14 to the non-assessment of damages, excuse me, under section 22,
yes.
correct, to the non-assessment of damages defenses, I think it's gonna go back to the same issue, it's just gonna come back there in a different way. So,
I'm not
In
just,
any event, I don't understand, and perhaps I don't need to understand the logic behind filing a brand new complaint. But is there any objection, I just want to know, it doesn't mean that I'm not going to do it anyway, to bringing this 19 CV 2632 into this session, into this civil session?
Your Honor, I had a couple of concerns about that. One that you've already addressed, that would have to be new discovery and the issue of damages and so on. Secondly, the declaratory judgment, all the prayers for relief, even in the new complaint,
Right,
are framed as a declaratory judgment.
I see that,
Assessment of damages is a jury, always.
right?
So I have that concern, and how that works. I guess we could cross that bridge when we come to it in the event the court consolidates them. There are ways to do both for different prongs of the
It just
case.
seems as a matter of judicial economy and otherwise for the parties' economy. Educating one judge to the issues is a little more simple than educating two judges to the same issues. And certainly as a matter of judicial economy, whether it's me or some other judge sitting here, it seems to me that these cases ought to be in the same session, even if they don't get consolidated at the end of the day.
That makes sense, Your Honor. I guess we're looking to dismiss both, as Your Honor is aware.
I know that's coming
I mean, we already have a Rule 12b6 served on counsel
on this one.
on the new one. So,
Bigger
and I
than
believe
that.
I believe that tolls the 30 days to raise any
It does.
It does.
To answer it.
to answer. And so, in the event that the Rule 12b6, which is also a Rule 12b9, because there's another pending case, this one, in the event we lose that motion, at that point would trigger the 30 days if we decide Section 22 applies, for me to raise the defense of validity at that point.
Right.
So there's multiple ways where one or both of these could be gone by then, so I'm struggling with the consolidation.
As to, I'm not making any decision with regard to consolidation. All I'm going to inform the parties is as to 1981 CV 02632, Madam Clerk. That case, City of Waltham versus the Trustees of Stigmatines Fathers, Inc., is being transferred to this session from the J session.
Yes, Your Honor.
All right. That leaves me with paper number 22, which is the plaintiff's, this was filed on the same day as the other litigation, but it's an emergency motion for attachment, but it's in this case. Attachment on the defendant's real and personal property and other property rights in the amount of $135,000. Are the parties wishing to be heard on that today?
I'll go with whatever Your Honor's,
Well,
we've been given a lot of time, I understand.
Well, let me just give you some feedback before we pursue this. It seems to me on a quick review of these papers that the city needs to file an affidavit that's in compliance with 4.1H. And before that affidavit is filed, no judge is going to look at this on its merits because you haven't met all the procedural requirements. Thereafter, the real focus is going to be likelihood of success on the merits, and to some degree that goes back to some of the decision making that we've been discussing today.
Again, just to be candid, Your Honor, I think Judge Horatius, after 2 days of trial, has already established that. She's clearly and explicitly said the city has a likelihood of success on the merits.
I know that's your argument, and I've read her opinion. I think that likelihood of success on the merits is also rises and falls off of this issue that we've discussed today. Because obviously, my interpretation of the eminent domain statutes is that you cannot use the declaratory judgment statute to truncate the 3-year period provided for in section 18. Your likelihood of success on the merits goes way down. on the case that's before me.
And clearly that, I understand what you're saying as to count one, but the attachment really goes to counts 2 and 3. And in fact, even the Pheasant Ridge case confirms when they talk about the damages issue that did not go forward. They say damages can be inferred by casting doubt on the ownership of land and causing them to incur expenses of this litigation. We're talking about basically $120 million and $7 million approximately a year. No, I'm wrong on that. 5.5% of a $380 million project that is just delay damages, separate and apart from the MSBA loan that's at risk. So, as I pointed out in the new aspects of the complaint, we understand now why they would never let us do any testing on the property. And we had to get a second order the first order from Judge Horatius after Judge Liu's order, because they continued to interfere, notwithstanding Judge Liu's order, with us gaining access to the property, because as we've since discovered after getting the order from Judge Horatius to let us back on the property, they have been contaminating the site. They've allowed all kinds of unlicensed, inappropriate dumping and filling on the site. That now that we've had preliminary geotechnical and LSPs on site, there's about $1 million worth of 21E problems and about $3 million worth of inappropriate dumping of unsuitable materials. That's very different from the current complaint. And that's part of the new complaint, as is the assessment of damages. So we're asking for an offset.
And all this makes me think one thing.
Yes, Sean. I understand.
We're gonna be at this for, and I'm gonna tell you this again, I said it the last time, I'm gonna say it again, I'm probably gonna say it every time I see you.
Yes.
Both sides want certainty. Whether, my job, I sit here every day, I try to get it right, and you too. I try to get it right. Maybe I get it right in this case, maybe I don't. What you're gonna get is my best effort.
Yes.
Regardless, either you're gonna be unhappy and you're gonna appeal, and you're gonna be unhappy and you're gonna appeal. And we all know what that means. That means years worth of future litigation. And I am going to encourage the parties. I know your C's apart, but find a way to resolve this dispute so that you can all move forward.
It's been attempted, Your Honor, when we meet,
Have you gone to a mediator?
we've met the
No.
price that they say is the highest price from the appraisal that
Have
they
you
got.
gone to a mediator? They work wonders.
Oh, I've been
Get
to
in a
many
room
meetings.
together with them and see
It won't
what's the
work.
worst that happens. Do you waste a day? You waste 2 days?
I don't dispute what Your Honor is saying, but when someone's asking, when we've met the appraised value that's based on an extraordinary assumption of a zone change, that's the highest that now we know they could never get because of this illegal dumping. And we met what their second attorney says was their highest and best use price. And they come in with a demand that was 70%.
I can't clutter my brain with, well, all I'm gonna say to you is again, I want you to, as, officers of the court, to
Yes.
get back and think what's in the best interest more globally of your client, which is not the battle that we're fighting here. It's the long-term picture for each of your clients. And what I see setting up here is a mushroom cloud of many years worth of litigation. And that doesn't achieve either the goals of the city, and I don't think it achieves the goals of the defendants either. They're off the property, that ship has sailed, with the assistance of a few of my colleagues. Now let's move on to the next chapter. I implore you to go see a mediator. The mediator's job is to point all the holes in their case, and likewise, both sides, to realize the risks. But what is a certain risk is you're going to pay, both of your clients are going to pay, even in man hours that your legal department is going, the town's legal department is going to dedicate to this case. In legal hours that the Stigmatine Fathers are going to pay to their attorneys.
I'm not,
Probably millions of dollars over years.
we've done that. When we made the taking of the adjoining property, I had no problem going to a mediator. Court ordered it, we did.
I suggest, can't make you, I suggest you do it again.
Your Honor, we've sent out a settlement demand a number of times. I know Your Honor doesn't want to get into the numbers.
I want
but
to get into
instead-
numbers, I don't want to clog my brain
Sure.
with it, you know mine, but
But instead of getting, all we get is more litigation. A second complaint now is preposterous to me, to file a new complaint, when all we hear about from the city solicitor's office is costs and millions of dollars at stake. For a drop in the comparative bucket, this whole thing, it would have been waived any and all rights under the sun. We just keep getting pounded with paper instead of an offer.
all right, I hear both of you. I hope you hear me. I think there's a better way to resolve this.
Final question, Your Honor, did the city file something at the beginning of this hearing that
No,
I
there
hadn't
was-
seen?
There was a piece of paper that came back to me from a non-party, third party, and when I realized that it was not a party to the case, I had my clerk hand it back.
So it's not going into the,
But Your Honor,
There- I mean, if you're not a party to this case, you really don't have a voice in this case.
I just didn't know what it was, I suppose.
Your Honor, there was a motion to strike that I handed you.
I have that.
You have that?
I have that.
Yes, I sent that.
There was another third-party letter. I did not, once I divined what it was, I sent it back.
Very good, thank you.
Okay. Matter is taken under advisement.
Thank you, counsel.
Thank you.
Court stands in
Thank you for the
recess.
time.
Thank you.
All rise, this court is still in recess.